My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about human versus consumer privacy rights. In the world, especially between the EU and the US, we have very differing ways that we approach privacy. In the EU, privacy is a fundamental human right. It has been for decades. And because they've woven that into their laws, that's very much a foundation. In the US, because a lot of our laws related to privacy are consumer-based or sectorial, meaning, it's based on the type of data that you have, is definitely very different from the EU, because there are a lot of gaps that can be left in terms of who is covered and who has certain privacy rights here in the US. One example of this is the current CCPA in California, which covers not only California residents, but also it has a lot of exclusions or exceptions, meaning that, for example, if you're a company of a certain size, if you're so small, the CCPA does not actually apply to you. Or if you have a certain number of customer records below the number that the CCPA accounts for, you may not have to actually comply with that law. But from an individual standpoint, regardless of whether they're dealing with a company that's large or small, they may still want to have those privacy rights to any data that they have. So this gap, and one example of this gap that I can explain is, let's say you take a picture with you and your grandma on Facebook. So you have a Facebook account, but your grandma doesn't have a Facebook account. So your picture goes on Facebook, you're tagged yourself, so Facebook knows who you are, and you may actually tag your grandma, her name. So even though your grandma doesn't have an account on Facebook, her data and her name is part of Facebook because of an action that you took. But if you had a problem with Facebook and you wanted to get your data off of it, or your grandma wanted to, she could not do that unless she was actually a consumer of Facebook. So that's an example of a gap between consumer privacy laws, where not all humans are consumers. So there are a lot of gaps there that don't get covered if you're not actually using a particular service, if you're not doing those types of things. One other exclusion that I can point as an example in the CCPA, that it doesn't cover non-for-profit organizations, whereas in opposition for the GDPR, it does cover any type of organization, almost any size, related to an individual's privacy right. So I think it's very hard to try to compare data privacy laws between the US and the EU, because they are very different in terms of the coverage of the rights of the individual, where our rights are so tied to our consumerism and how we use data, or how information is captured by third parties, as opposed to being a fundamental right that's expressed in our particular laws. As we look toward the future about having possible national or federal data privacy legislation, this may be a big issue that has to be sorted out, because having privacy as a fundamental human right gives people more coverage in terms of their own individual privacy, and it eliminates a lot of the gaps that happen if you're looking at privacy rights only from a consumer lens. That's it. Thank you.